Arizona law establishes detailed requirements for public reports, documents that protect consumers purchasing subdivided or unsubdivided land by ensuring they receive accurate material information before signing a contract. The Arizona Department of Real Estate, ADRE, administers these statutes to promote transparency, prevent fraud, and ensure the orderly sale of land and subdivisions throughout the state. Under ARS, Paragraph 32-2181A, a developer must obtain a public report from the real estate commissioner before advertising or offering lots for sale or lease. This requirement applies to any subdivision of 6 or more lots, parcels, or fractional interests. The public report includes essential disclosures about title conditions, access, utilities, water supply, zoning, drainage, easements, and encumbrances. Advertising or selling lots without an approved public report constitutes a violation subject to civil penalties and license discipline. In some cases, the commissioner may grant a special request under ARS PGR 32-1297.02c, allowing limited or conditional approval of sales before full completion of a public report. This exception is rare and typically applies when specific conditions or documentation are pending, provided the developer offers adequate disclosure and protection to the buyers involved. When selling vacant land, accurate legal descriptions are essential. These descriptions identify property boundaries and ensure the land can be properly conveyed and recorded. The meets and bounds system uses distance, meets, and direction, bounds, from a defined starting point, often referencing natural or artificial monuments. This method is common for irregular or rural parcels not part of a recorded plat. Adverse possession, defined under ARS, Paragraph 12-526, allows a person to acquire ownership of another's land if they possess it openly, continuously, and hostilely for a statutory period, typically 10 years. In real estate practice, title companies and agents must be aware of potential adverse possession claims that could cloud title and affect marketability. Crop rights may arise when agricultural land is sold during an active growing season. Unless stated otherwise, the party owning the crops, usually the seller, retains the right to harvest them after closing. Agents must clarify crop rights in contracts to avoid disputes. Prescriptive easements, as illustrated in Paxson v. Glovitz, Arizona's App R. 2002, are similar to adverse possession but apply to the right of use rather than ownership. In this case, the Arizona Court of Appeals held that continuous and open use of another's property for access or utility purposes could create a legal right to continue that use after a statutory period. Licensees should ensure such easements are disclosed and properly documented before closing. Article X of the Arizona Constitution establishes state trust land, which is land granted to Arizona upon statehood to benefit public institutions, particularly schools. State trust land cannot be sold or leased without following strict procedures overseen by the Arizona State Land Department, ASLD. Real estate licensees must confirm whether land offered for sale includes or borders state trust land, as such properties may carry usage restrictions. ARS, Paragraph 32-2101-62, defines unsubdivided land as land divided into 6 or more parcels, each between 36 and 160 acres. By contrast, ARS, Paragraph 32-2101-59, defines a subdivided lot as land divided into 6 or more parcels of less than 36 acres each. The distinction determines which disclosure and reporting requirements apply. For unimproved subdivided lots or unsubdivided land, AAC R4 28804 provides rescission rights, allowing purchasers to cancel the contract within 7 days after signing if they have not inspected the property or received the public report. This protects buyers from uninformed land purchases. Under ARS, PRS 33-422, sellers of 5 or fewer parcels of land in an unincorporated area must provide an affidavit of disclosure to buyers at least 7 days before closing. This document includes critical information about access, utilities, water supply, flood hazards, and zoning, ensuring buyers understand potential limitations on the property. ARS, Paragraph 32.2181E, requires a public report for all developments consisting of 6 or more lots, parcels, or fractional interests, regardless of improvement status. The ADRE issues this report after reviewing the developer's application, title report, plat, and disclosure materials. For properties within active management areas, AMAs, an assured water supply is required under ARS, Paragraph 32.2181C. The Arizona Department of Water Resources, ADWR, must certify that the subdivision has access to a 100-year water supply that meets quality and legal standards. This requirement ensures sustainable water management in high-demand areas like Phoenix, Tucson, and Prescott. Outside of AMAs, ARS, Paragraph 32.2181F1, 2, requires developers to disclose the adequacy of water supply but does not mandate a formal assured water certification. Developers must, however, inform buyers if the water source is considered inadequate by ADWR, allowing consumers to make informed decisions. ARS, Paragraph 32.2181.R1, outlines the Commissioner's powers to investigate violations, suspend or revoke public reports, and require corrections or amendments to inaccurate disclosures. The Commissioner may also issue cease and desist orders against unlicensed or fraudulent activity. ARS, Paragraph 32.2181.02, lists exemptions from the public report requirement, including sales to builders, bulk sales of lots to one purchaser, and certain commercial or industrial properties. These exemptions are intended for experienced buyers, not requiring consumer-level protection. ARS, Paragraph 32.2184, governs amendments to public reports. If there are material changes in a subdivision, such as zoning updates, water supply modifications, or new encumbrances, the developer must file an amendment with ADRA before selling additional lots. This ensures that all buyers receive current and accurate information. Finally, ARS, Paragraph 32.2181.03, regulates developer lot reservations. A developer may accept refundable deposits up to $5,000 per lot before the public report is issued, but the deposit must be placed in escrow, and buyers must receive written notice of their right to cancel at any time before signing a purchase contract. This allows developers to gauge interest while protecting consumer funds. Together, these laws create a structured and transparent process for selling land and subdivisions in Arizona, ensuring that buyers are informed, water resources are verified, and developers remain accountable to the public. Arizona has strict regulations governing timeshare sales to protect consumers and ensure transparency in how vacation ownership interests are marketed, sold, and managed. Timeshares involve shared ownership or use rights in a property for specific time intervals and must comply with Arizona Department of Real Estate, ADRE, oversight before they are sold or advertised. Under ARS, Paragraph 32.2197.01, all timeshare projects must maintain a 1-to-1 purchaser-to-accommodation ratio. This means there must be at least one available unit or interval for every purchaser, ensuring that buyers can use their property as promised. This rule prevents overselling, where too many ownership interests are sold compared to the number of available time periods or units, protecting buyers from being denied use of their purchase timeshare intervals. According to ARS, Paragraph 32.2197.02a, it is unlawful to offer for sale or solicit sales of timeshares until a public report has been issued by the Real Estate Commissioner. This statute ensures that consumers are not misled or pressured into buying a timeshare before receiving full disclosure about the property, its operation, management, and associated costs. However, ARS, Paragraph 32.2197.02c allows a pre-sales request to the Commissioner. A developer may apply for conditional approval to begin taking reservations before the final public report is issued. To qualify, the developer must demonstrate that essential conditions, such as title ownership, legal documentation, and consumer protections, are met. Buyers must be informed that the project is in the pre-approval stage and that all deposits are refundable until final approval is granted. Under ARS, Paragraph 32, 2197-03A, all purchase agreements for timeshares must be in writing, and a paper copy must be delivered to the purchaser at the time of execution. This requirement ensures that buyers have clear, documented evidence of the terms, including price, use rights, and cancellation procedures. ARS, Paragraph 32, 2197.03b, provides buyers with rescission cancellation rights. Purchasers have 7 calendar days after signing the contract to cancel the agreement without penalty or loss of funds. This cooling off period gives consumers time to reconsider their purchase after reviewing all disclosures and costs associated with the timeshare. Developers and licensees must promptly refund all payments if the buyer exercises this right, if a material change occurs in the timeshare plan after initial approval. ARS, Paragraph 32, 2197-004A, requires the developer to notify the ADRE of the change and submit updated information for review. A material change could include alterations to the project's ownership, amenities, management, or financial structure that might affect a buyer's rights or obligations. Under ARS, Paragraph 32, 2197.04b, the Real Estate Commissioner has the authority to take action when a developer fails to disclose or report such changes. The Commissioner may suspend or revoke the public report, impose penalties, or require corrective disclosures to ensure all purchasers receive accurate, up-to-date information. ARS, Paragraph 32, 2197.07a, and B, govern the issuance of a public report for timeshares. Before the Commissioner grants approval, the developer must submit a detailed plan that includes legal descriptions, management agreements, escrow instructions, budgets, and evidence of title. The Commissioner examines the plan to ensure compliance with all applicable laws and consumer protections. No sales can occur until this approval process is completed. Once approved, ARS Paragraph 32, 21197.08 requires that the public report be available in writing and distributed to all prospective buyers before signing a contract. The report must include detailed information about ownership structure, use rights, maintenance fees, exchange programs, and management obligations. This ensures full transparency and informed consent from buyers. If the developer modifies the timeshare project after approval, ARS Paragraph 32, 2197.08 will be requires the submission of an amended public report to the ADRE. This amendment must describe all material changes to the project, and the Commissioner must approve it before the developer resumes marketing or sales. This process ensures that all buyers are informed of any new or altered conditions that could impact their ownership or usage rights. Collectively, these statutes create a strong framework that ensures fairness, accurate disclosure, and consumer protection in Arizona's timeshare industry. They require full transparency before sales, provide rescission rights, and hold developers accountable for maintaining an equitable balance between buyers and accommodations.